How Canada's immigration reset in October 2025 changes everything for students, workers, and visitors. A new era of managed migration. Hello and welcome. I'm Jonjua from Travel Tree YouTube channel, and today, we are addressing one of the most critical and widely discussed topics in Canadian immigration history, the profound shift in policy and enforcement coming into full effect in late 2025. The core message is clear. Canada is transitioning from a system focused primarily on welcoming high volumes of newcomers to one prioritized for compliance, accountability, and the long-term integrity of its economic and social fabric. This is not merely an adjustment, it is a fundamental recalibration of the rules for maintaining your legal status as a temporary resident, a student, or a worker. For those currently living, studying, or working in Canada, the year 2025, particularly the fourth quarter, marks a decisive moment. The government strategy, often referred to as managed migration, is leading to the strengthening of existing laws under the Immigration and Refugee Protection Act, IRCC, making even small errors potentially catastrophic. The stakes have never been higher. Failure to adhere to the fine print, from timely document renewal to full transparency in your applications, is now under a microscope with enhanced digital oversight and clear political commitment to system integrity. Every immigrant, student, and worker must now operate with a new level of diligence. Stay with me as we break down the critical areas where the new focus on compliance and security, driven by recent legislative changes and regulatory updates from Immigration, Refugees and Citizenship Canada, IRCC, and other government agencies, will reshape your life in Canada and provide you with actionable knowledge to safeguard your status. 1. Expired, forged, or inauthentic documentation. The very foundation of your stay in Canada is your legal documentation. The days of administrative leniency for short lapses in status or simple oversight are drawing to a rapid close. In a key move to bolster border and system integrity, new regulations have empowered Immigration and Border Services officers with explicit authority to cancel electronic travel authorizations, ETAs, and temporary resident visas, TRVs, if a person's status or circumstances change, or if officers are not satisfied that the person will leave Canada by the end of their authorized stay. This authority is not just for future applicants, it extends to documents already issued. What this means for you. Timely renewal is non-negotiable. An expired work permit, study permit, or even a permanent resident, PR, card that has passed its expiration date can now trigger an immediate, automated flag in interconnected government databases. You must initiate renewals well in advance. The digital paper trail. The government is investing heavily in linking immigration records with border control systems. Any discrepancy, expired status, or, most critically, the use of forged documents, fake letters of acceptance, forged job offers, or altered travel documents, will result in an immediate finding of misrepresentation and inadmissibility, leading to swift investigation and removal proceedings. The consequence for using fake documentation is a harsh 5-year ban from Canada, in addition to deportation. The message is unambiguous. Absolute authenticity and meticulous attention to expiry dates are now mandatory. 2. Criminal convictions and security concerns. Canada maintains an extremely strict stance on criminality, and recent government efforts have reinforced this commitment to national security and public safety. Inadmissibility on grounds of criminality has always been a key reason for deportation, and the 2025 framework is focusing on its more efficient and rigorous enforcement, particularly for non-permanent residents. The expanded security lens. Minor offenses matter, while serious crimes like theft, assault, or drug trafficking are clear grounds for inadmissibility. Even offenses previously considered minor by some, such as driving under the influence, DUI, can and do result in a finding of inadmissibility and trigger deportation proceedings for temporary residents. In Canada, a DUI is a serious criminal offense. Enhanced intelligence sharing. Recent legislative efforts, including the introduction of new Border Security and Integrity Acts, aim to strengthen the government's ability to share intelligence with domestic and international partners. This is explicitly designed to target individuals linked to organized crime, extremism, or other serious security risks. The threshold of admissibility: if you are a temporary resident, student or worker, and you are convicted of an offense that carries a maximum prison sentence of 10 years or more in Canada, or if you commit a series of less serious offenses, you will be found inadmissible. The government is focused on making the enforcement and removal of non-citizens who commit crimes swifter and more absolute. The core principle remains: your continued residency in Canada is contingent on upholding Canadian law and posing no risk to national security. 3. Overstaying visas and unauthorized employment. The integrity of Canada's temporary residence programs hinges on one fundamental promise: that visitors, students, and workers will leave when their authorized stay ends. New regulatory measures are eliminating the historical leniency that sometimes applied to minor overstays. Digital tracking and zero tolerance for overstays. Flagged by the system, advanced digital tracking systems and enhanced data analysis are designed to automatically flag individuals who remain in Canada beyond the expiry date of their visa, study permit, or work permit. This automation eliminates the chance of human oversight or delay, leading to swifter intervention by the Canada Border Services Agency, CBSA. The 90-day grace period: while an applicant who applies to renew their status before it expires has implied status, anyone who applies for restoration after their status has expired only has 90 days to apply. Under the new enforcement environment, even a small delay can risk the denial of the restoration application, leading directly to a departure or exclusion order. Unauthorized work: a direct path to deportation. Working beyond limits: this is a clear violation of the terms and conditions of your visa or permit. Unauthorized employment includes working with an expired permit, working more hours than allowed, or working for an employer not listed on a closed work permit. Targeted compliance checks: the government's focus on system integrity is leading to more targeted and frequent compliance checks on employers and foreign nationals. Discovery of unauthorized work will result in a finding of non-compliance with the IRPA, leading to a potential removal order. Temporary status means a temporary stay with specific, legally defined conditions. Violating the terms of your stay is a willful defiance of the law. 4. Misrepresentation in immigration applications. Misrepresentation, providing false information or withholding material facts, has always been a severe offense under the IRPA, but the new framework emphasizes a zero-tolerance approach, even for errors considered minor. The scope of misrepresentation. Small errors as fraud: IRCC officers are trained to treat omissions or incorrect information, whether related to educational history, employment details, family members, or travel history, as deliberate attempts to deceive, even if you believe them to be small errors. If the false information could have led to an approval that would otherwise have been denied, it is considered a material fact. The consequences: a finding of misrepresentation triggers an automatic 5-year ban from Canada, a devastating consequence that applies to future visa, study permit, work permit, and even permanent residence applications. In this heightened atmosphere of compliance, applicants must exercise extreme caution. Every detail in your application must be factually correct and verifiable. 5. Financial stability, public health, and judicial compliance. The final pillars of admissibility, financial independence, public health, and respect for legal orders, are also being reinforced as part of the system integrity focus. Financial dependence on the state. Review and instability: while temporary financial hardship is understandable, repeated and chronic dependence on provincial or federal welfare programs, social assistance, can signal to IRCC a lack of financial self-sufficiency. Under the IRPA, a person can be found inadmissible if they are unable or unwilling to support themselves and their dependents. While this is primarily assessed for permanent resident applicants, prolonged or repeated reliance on public funds by a temporary resident may trigger a review of their ability to meet the requirements of their current status. Public health risks and medical cooperation. Safeguarding public health: the IRPA contains clear provisions for inadmissibility on medical grounds, specifically for individuals whose medical condition Endangers public health, e.g., active, untreated infectious disease. Endangers public safety. Causes excessive demand on health or social services. Compliance with orders. The new emphasis on public health compliance means that individuals who actively refuse necessary medical treatment that is a condition of their entry, or who ignore legally binding quarantine or isolation orders, could face a finding of inadmissibility and subsequent deportation. Non-compliance with court or border orders. Willful defiance, failure to comply with an exclusion order, a deportation order, or any other formal legal or border services order is viewed as willful defiance of Canadian sovereignty and law. Such actions leave no room for appeal and will result in the strongest possible removal action. 6. Specific program integrity for temporary residents, students and workers. The broader policy changes being implemented have already begun to reshape the landscape for those seeking temporary status. Students. The government has introduced an official cap on new international student intake, alongside the new Provincial Attestation Letter (PAL) requirement. This shift, along with new rules restricting who qualifies for a post-graduation work permit (PGWP) and open work permits (OWPs) for spouses, is fundamentally aimed at ensuring that every international student slot is a genuine academic pursuit that aligns with Canada's capacity to support newcomers. Compliance with academic progress reporting by designated learning institutions, DLIs, is now a central focus of integrity. Workers. Changes to the eligibility for open work permits for spouses of temporary foreign workers, now restricted to those in specific high-skilled categories, highlight a move to use temporary foreign worker programs to fill specific, high-priority labor shortages, not as a general means of family migration.